Welcome to Immigration Quicktake. This is Ellie Rutledge Silver with the American Immigration and Lawyers Association. The Department of Homeland Security released a proposed rule for high-skilled non-immigrant workers. Here to discuss the details is Betsy Lawrence, AILA's Director of Liaison. Betsy, thanks for joining me. What does this proposed rule say?
Thanks, Ellie. There's actually a lot that is packed into this rule, so I'm going to try to just hit the main highlights. First, the rule would codify a lot of existing agency guidance on the American Competitiveness in the 21st Century Act and the American Competitiveness and Workforce Improvement Act, both of which were passed more than 15 years ago. So this would include things like H-1B extensions beyond the general 6-year limitation. It would include permanent portability to a same or similar occupation and H-1B portability. The rule would also codify existing agency guidance on H-1B cap exemption and, importantly, would expand the definition of a related or affiliated nonprofit entity to include nonprofit entities who are under a written contract with an institution of higher education. The rule would also provide protections for individuals who are stuck in the long immigrant visa backlogs and include provisions such as relating to priority date retention. And also, there also is included a rule that would recognize for very limited purposes the continuing validity of an immigrant visa petition, where that petition was withdrawn by the employer or where the employer's business terminated, as long as there was no fraud or misrepresentation which led to revocation of the petition. The proposed rule also includes grace periods for certain non-immigrant workers and includes what appears to be a very limited provision that would provide work authorization to certain employment-based intending immigrants.
Thanks, Betsy. Could you tell me more about the employment authorization provision?
If the rule is implemented as written, it would permit a 1-year employment authorization card to certain employment-based individuals. In order to qualify, they have to show 4 things. First, that they are currently in a valid non-immigrant status, and the types of non-immigrant classifications are limited to certain categories. Secondly, they have to show that they have an immigrant visa petition that is approved. They have to show that an immigrant visa is not currently available and that their priority date is within 1 year of becoming current. And lastly, and probably most importantly, they have to show that compelling circumstances warrant the approval of employment authorization. So at this time, DHS has not defined what compelling circumstances are, but it has stated that the fact that the individual is approaching or has reached the statutory maximum on their non-immigrant visa classification is not in and of itself sufficient. And they also have to show that the compelling circumstances are not within their control. And in addition, it should be noted that if a person is granted employment authorization under this provision, they're going to be required to relinquish their non-immigrant status, which means that any future opportunities for change of status or adjustment of status are going to be severely limited or probably eliminated. So for all of these reasons, it appears that this provision allowing for employment authorization for employment-based non-immigrants is going to be extremely limited.
Are there any concerns?
Well, yes, there are a few concerns. One provision that particularly comes to mind are some provisions that relate to the adjudication of employment authorization applications. The proposed rule would eliminate the current provision, which requires adjudication of employment authorization applications within 90 days, and would also eliminate the provision requiring an interim employment authorization card if the 90-day adjudication period cannot be met. Instead, what DHS is proposing is to extend employment authorization in renewal applications automatically for 180 days. But it's also limited to certain classes of employment authorization applicants. Some classes which are included. In fact, the rule in the supplementary information lists 15 categories of EAD applicants who would be eligible for this automatic extension. And those include applicants for adjustment of status, asylees and refugees, applicants for asylum, TPS, but noticeably not included are DACA renewal applicants and also H-4 EAD renewal applicants. So those are some concerns that we have, and AILA will of course be submitting comments to this proposed rule, and we will certainly address those concerns there.
Thanks, Betsy, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.